The Federal High Court in Abuja has dismissed a suit instituted by the federal government seeking to extradite suspended Deputy Commissioner of Police Abba Kyari to the United States of America. Justice Inyangeko held that the extradition request filed by the Attorney General of the Federation lacked merit and is liable to dismissal. Judiciary correspondent Celestina Area was at the court and filed in this report.
The Attorney General of the Federation had filed an extradition application at the Federal High Court in Abuja following a request by the diplomatic representative of the U.S. Embassy in Abuja. The request from the U.S. authorities to Mr. Malemi is for the surrender of Abba Kyari, who is the subject of superseding 3-count indictment. In his defense, Mr. Kyari had held that he has not committed any offense to warrant the federal government ferrying him to America. The suspended police chief told the court that more than a year before his arrest, he had written the Attorney General of the Federation and the Inspector General of Police, notifying them that he had opened a channel of communication with the suspected internet fraudster Abba. In the 2-letter tendered in court, Mr. Kyari explained that the purpose was to gain the confidence of the suspected fraudster and lure him to come to Nigeria, where an ambush was already laid for a sting operation by his own strike force. Delivering judgment, Justice Inyangeko held that the federal government has no basis to fight the extradition request, having put Abba Kyari on trial in Nigeria in relation to allegations against him in America. The Extradition Act is clear as one which prohibits granting extradition request for someone who has a pending criminal suit yet to be discharged by a court of competent jurisdiction, and in the case of the suspended Deputy Commissioner of Police Abba Kyari, who faces another case of alleged drug trafficking. The trial judge expressed dismay that the Attorney General Abubakar Malemi, being the chief law officer, should have known that the extradition suit was incompetent.
The application for extradition, as made by the Honorable Attorney General of the Federation, was brought in bad faith. It was not brought seriously. It was an attempt to hoodwink and attack our clients. And it's incompetent, and it was dismissed and was struck out and dismissed together on the merits too, that there's no merit in it. And the basis of the finding is that there is also a subsisting criminal case filed by the same Attorney General before filing the extradition application. And he cannot pretend to say that he's not aware.
The basis of the extradition suit against Mr. Kyari was hinged on his alleged involvement with internet fraudster Abba, commonly known as Hush Puppy, who was convicted by a U.S. court. Celestina Area, TVC News, Abuja.
All right, lawyer and social development advocate Olatunbosun Osifowora joins us now to speak on this. Thank you so much for joining us on TVC Breakfast.
Good morning. Always a pleasure to be here.
Right. Now, so many reactions. This judgment has been generating a lot of reactions, and there are those who are of the opinion that the Attorney General of the Federation should know better, that Kyari's case is fait accompli and cannot be extradited to the U.S. since he's facing a drug-related crime. And so they have termed this move a hypocritical move, so to speak.
Yeah, well, I think it's quite unfortunate that the office of the AG hasn't been very tidy in respect of this thing, because if you look at the Extradition Act itself, everything is hinged on the president. And you know the president is not the one that's going to do it. So it falls automatically on the Attorney General's office to do this. Now, so if in one breath, the Attorney General's office is aware or is prosecuting Abba Kyari in a particular case, I think it is incumbent on them also. It tries to say that the office is supposed to know the law and the workings of the law. Now, and basically, if you look at the Extradition Act, Section 1 says that where a country is a part of a treaty, it is supposed to allow any criminal to be given to another country where there's a criminal charge against that person. Now, but if you go further to Section 2 and Section 3, subsection 6 of the same Extradition Act, it says plainly that if somebody is going through a trial or it has been convicted of a crime in a particular jurisdiction, then he is no longer subject to being extradited to another jurisdiction. So I think this is very clear, and this is very simple position of the law. So the mix-up coming from the Office of the Attorney General is not too tidy, and it doesn't really work well, as you can see. And the judge was very right in dismissing the case. He didn't just dismiss, he struck it out and dismissed it at the same time that this has no merit and shouldn't be brought up again. Let this man go and face his criminal charge, and then according to the law, and let everything be done decently, properly, and in order. That's it.
How do you distinguish between one case and the other? We need clarification here.
Okay, let's put it in perspective. If you look at what's happening, there's the NDLEA case, which is a criminal charge against Abba, Kyari, drug peddling and tampering with, samples and all that, some exhibits and all those things. So that's a charge on its own. Now, and that is a case on its own for which he is liable, and he has to come and explain his position. Then also, if you look at the one that has been brought, the issue of Ramon Abba, which we all know as Hush Puppy, that is another case on its own in another jurisdiction. And it is subject of extradition because Nigeria has signed treaties with the United States in respect of extraditing criminal fugitives, basically, which Abba Kyari has been fingered to be one. And we all saw the processes of the American court. And in fact, we saw Abba Kyari running quickly to, speak for himself in respect. I mean, that's a charge has been established against him in the United States. So the cases are different and they can be well distinguished. But as it stands, I know people have read so many meanings to this, maybe somebody trying to maybe back Abba Kyari out of this by filing something. But if you look at what the NDLEA has brought, sincerely speaking, it's a very severe case, and he needs to answer for it. I mean, this was once our super cop, and now fiddling with evidence, getting involved in drugs. That's a case on his own, and we need to get to the end of it. So we cannot abandon that and then run and start, taking him, extraditing him to the United States for something else. Now, you may want to bring out the issue of maybe first in time that I'm aware that the U.S. case precedes the NDLEA case, but at the same time, it is necessary to state that a case is a case, a criminal charge is a criminal charge, and according to the law, he has to answer for it. So we'll take the one of Nigeria first, let him do it. If he's convicted or released, then this other one can actually come up and still be brought on. Criminal cases are not statute barred where you say after a period of time, nothing to happen, just forget about it. No. A criminal case exists for life, and we've seen it in many cases. You saw even in the US, you saw the case of Cosby, all those allegations were around 78, 77, or early 80s, and you saw how the whole thing panned out. So even if whatever the outcome of the NDLEA case here, definitely that other case still exists and it can still be brought at any time. So I don't see any foul play or any hanky-panky in this present Nigerian case.
All right. Now, let's look at it this way, trying to create some scenarios here. Of course, we will not preempt what the outcome of the cases will be. But in a situation where someone is tried, there is an extradition request on him, but he has a case to answer back in his own country, and he's tried and convicted, and he needs to serve the term as the case may be. What becomes of the extradition request?
Yeah, the extradition request stays in abeyance for the period in which he will serve the case. In fact, if you look at the extradition law, it's very clear. Now, the cases earlier on, Mr. Sam said earlier that can we distinguish between the cases, and I think we've done that successfully. what he's facing here is a case related to drugs, and what the American case purely has to do with fraud. Now, so they are quite distinct cases. And like I said earlier also, criminal cases are not statute barred. Now, so what happens is if he's convicted here and he serves his term, the issue of extradition can still be brought up. Now, if you look at the extradition laws, it says specifically that there are instances where a person can be allowed, where a criminal won't be given to another country in respect of extradition, and the instances are clear. It says one, if it's something prejudicial, if it's something that has to do with maybe somebody being persecuted for religious basis, or if he has done his term in respect of that particular case in that present jurisdiction. Like, let's say the case he's wanted for is the the fraud-related case. He has been convicted in Nigeria and sentenced, then there's no cause for extradition. But in this instance, what he's facing here is the one for the NDLEA. So what happens in that instance is that if this is done, much later it can still be brought up. You remember the case of Kashamu, the late Kashamu, way back. He was trying to explain certain things, and the position was clear that, see, the law is the law, and the law can't be manipulated, no matter how much you try. Now, so in this instance, Abba Kyari in Nigeria is facing a drug-related case, which is distinct from the American case. So if it's, like you said, we can't preempt, but whatever the outcome of this Nigerian case, the one with the NDLEA, if it finishes, the issue of extradition can still be brought up because it's a completely different thing in the United States.
Right. So if you are saying that this matter, there's no one trying to cover him or protect Abba Kyari, so to speak, then when should we have filed the extradition suit?
You see, everything rises and falls on the office of the Attorney General. Now, if you blame them for not, with extradition, there's a whole lot of paperwork between the two countries. Now, so what happens is, if they had finalized before this issue of NDLEA came up, well, if you say they may have their reasons for not doing it on time, but you can see this matter is in court and the court just actually pronounced in respect. And then the court says, forget about it, let him face the one that is here. This person, by the law, by our extradition laws, has something to do here, has a case to face here, and let him do that first. Let him do that. So they dismiss the issue of extradition as it stands. Now, and that is the position of the law, and the law is the law. There's nothing you can do about that, against the law. Now, so in this instance, like I said, if it's done or whenever it's done, then this one can be raised also. Now, so whatever happened between when the whole extradition issue started and when this NDLEA case started, well, that can be left to, or that is left to the office of the Attorney General to come and explain to the public or the people of Nigeria. But as it stands, there's a legitimate cause, and the judge is right and right in dismissing the case and asking Abba Kyari to face the one that is presently here and let them be start with it or get done with it before anything can be done. So as it stands, the issue of extradition is not in focus. What is in focus as it relates to Abba Kyari is the issue of NDLEA drug tampering with evidence and all that, or sale of evidence as it stands, and that's what he is supposed to answer for.
Now, which one is more important? Is it the case that comes first or the country in which the person resides? Is there an issue of nationalism in law in terms of precedence of case or sequence of cases? And how does it relate to this one?
Well, okay. That's a very fantastic question. Now, as it stands, the law didn't prioritize what should come first. What the law specifically says in Section 3, subsection 6A of the Extradition Act is that where a person is facing criminal charges here, or a person is before the court in Nigeria, then he cannot, expressly stated, he cannot be transferred or given out for extradition. So I think that puts whatever is happening here first. Now, regardless of what has transpired from the beginning, the fact is, once a case has been established against a person in the country, then extradition takes second base, takes the second stage.
All right. Now, the Minister of Justice filed a case against against Abba Kyari, knowing that having that on one hand, they were still the ones, or he was still the one, or the office filing a case of extradition. Would you see this as judicial mischief, or what can we interpret of this?
It is not judicial mischief, and the Attorney General is an officer of the law, and what I can say is that it's not a tiny office. It's not just a tiny law office. They have 1,000,000,001 cases that they face every day, for want of better description. Now, but sometimes you can always leave room for mix-up here and there. Now, but having seen that, I think not holding brief for the office of the AG, it's necessary to be tidy in whatever we do. And in this case, I don't think the office has been tidy enough, because you cannot be prosecuting somebody on one hand and then you forget. Abba Kyari is no small fry. I mean, the case is a case that has generated a lot of buzz, and everybody is really interested in what's going on. So you can't be filing one case on the one hand and then for the same person, and then you bring up another case which the law already speaks to. Now, so I think it's a bit untidy on the part of the office, but it is not a question of mischief.
All right.
It's not a question of mischief. I can speak for that office. That I don't see any mischief being played here. What has happened is maybe a mix-up or somebody not being tidy with the job.
All right. Olatunbosun, we need to quickly go on a commercial break. When we return, we'll continue the conversation with you. To stay with us. Thank you for staying with us. Before we went on the break, we've been looking at the Federal High Court's in Abuja's dismissal of a suit instituted by the federal government to extradite suspended Deputy Commissioner of Police Abba Kyari. And we've been speaking with lawyer and social development advocate Olatunbosun Osifowora. Are you still there? Olatunbosun, are you still there?
Very much, yeah.
All right.
I'm wondering if the Attorney General knew about all of this. Why go through the charade of taking the matter to the court, and why not just communicate with the United States and say, well, we have a case here and we have to resolve it first before we'll go further with extradition? Why go through this charade? Is it something that can be explained?
Well, normally, even the process of extradition is not something that the Office of the Attorney General does by itself. What happens is they'll have to go to court, they'll have to establish facts before the court, and then before the whole extradition process is done. So basically that's how it works. Now, so it's not just a case of communicating with the US and saying this is it. But like I said earlier, I think the office wasn't tidy in the fact that it has put so much resources in something that was avoidable. Now, as it stands, what could have been done is to get in touch. The position you just pushed now is that the office can, through certain communication, get in touch with the United States Home Office and tell them that, okay, by the provisions of the law, which you are aware of, this man is facing certain charges here. But I also presume that the whole extradition thing had started before the NDLEA case against Abba Kyari came up. So I wouldn't want to blame the Office of the Attorney General that much concerning, going to court, and like some people will claim that they wasted, the resources of the
But
country.
that is what has happened.
That are not very available.
Doesn't he have the right to halt the process and say, okay, something is come up and we need to hold off? I mean, there's no hard and fast rule about continuing a case when you know that it's heading nowhere and you are spending state resources and stuff like that. If there was no underhand considerations, if I may put it that way.
Well, no, I wouldn't subscribe to underhanded considerations. I want to pitch my tent. I would want to pitch my tent with the fact that this extradition process had started before this case came up, and that's why now. But I think wisdom dictates that the office should have withdrawn, knowing the position of the law. But sometimes it's also good to satisfy the process and also make people see that, okay, well, this is a case of transparency. As it stands now, nobody is going to vilify the Office of the Attorney General any longer. You can imagine being in the process of this extradition thing and then them pulling out and saying because of the NDLEA case. You know what will happen? People will go on social media, people will say all kinds of things. But as it stands, the office allowed the thing to, thin out. And the court came out and said, see, this is the position of the law, this is how it stands. And I think the office has been justified and the office has been allowed to, run the course. And the court has taken a definite position. Nobody's going to say anything. Unlike if they had pulled out from the whole extradition process. I assure you, the optics, and the Nigerian public, they will react funny that why would they pull out? Why would they do this? We know how this thing works. So
Yeah,
I think
sorry.
on the one hand, without holding brief for the office, I think they allowed it to just, thin out and let the courts pronounce. And so they can stand and say, okay, fine, we have done our bit.
Sorry, Olatunbosun, I just need some clarification. If the process, the extradition process started before the Nigerian case started, could it be read that the Nigerian case started in order for us to get to this pass where we'll have to throw off the extradition and then have the Nigerian case and then have our man here in Nigeria and not go there?
That fact is beyond me. It looks like
All right.
It's beginning to look like a movie script.
All right, but as it is, is it possible to have him tried in absentia? Is this a case that that is a possibility in the U.S.?
I think what happened in the U.S. is the trial almost has been concluded. There's a judgment. It was the judgment that indicted him, and that was that's what gave vent to the whole issue of extradition in the first place. So the one in the U.S. has been concluded. They just need him to come and answer to his own part, because all the evidence from the judgment from what we read, speaks to the fact that he is culpable to a very large extent. Now, so I think the trial has been concluded at the U.S. end. They just need him to come and probably just, it's not just trial that you are extradited for. Sometimes it's for you to go and serve your punishment in that jurisdiction. Now, so as it stands, if you look at most of all the parties, they've given evidence. Some have been convicted. Some have been, allowed to go in the whole case from what we read when this whole case started. Now, so in this instance, I think let's just hold on to our laws. Let's stay with the law. Let's pan to the position of the law. And let's see how everything also will work out. But as it stands, the court has stated that as far as extradition is concerned, that there is no case, that Abba Kyari has a case here, and by the extradition laws, that he has to first finish the case here before the issue of extradition is ever considered by the Nigerian courts.
Right. Olatunbosun, we must thank you for your time on the program. A lot of Nigerians are interested in this matter and the processes, and we can only hope that justice is done and also seen to have been done. Thank you for your time.
My pleasure.